So while we have a series of prepared questions, we encourage you to stay engaged and raise whatever questions you want throughout the presentation or at the end if you prefer, if time allows. So to ask a question, simply raise your hand and our team, particularly Nick, who'll be arriving here in a few minutes, will circulate the microphone. For those joining us via Zoom, please post your questions on the chat and Megan will be monitoring those. It is a pleasure to moderate this panel. In a minute, I will introduce our distinguished speakers, but first, I would like to take a moment to recognize our honorary guests. We have here, sitting in the front row, Judge Moore. It's an honor to have you today. I know also present here shortly will be Judge Porter, Judge Jones, and Judge Weeks. And we're hoping that a couple of the justices will be accompanying us today. But I've been informed that there was a swearing-in ceremony, so they may be arriving a little bit late. So we're also very grateful for the presence of our board members. Without you guys, this essential work would not be possible. Now it is my distinct honor to introduce our wonderful panelists. First, we welcome Hannah Makowski. Hannah resides in Chicago and works as a court management consultant with the National Center for State Courts. Prior to joining the NCSC, Hannah was a staff law clerk at the United States Court of Appeals for the Seventh Circuit. During law school, Hannah worked with several public interest organizations, including as a participant in the Housing Law Clinic, where she provided services to individuals facing housing instability. Before law school, she worked as a high school teacher in Chicago. Hannah earned her bachelor's in public policy and master's in education from the University of Michigan. And later on, she went on receiving her JD from the Harvard School of Law. Hannah works and tries to improve access to justice across the United States through their work at the National Center for State Courts. Next, also joining us from the National Center for State Courts is Andy Workes. We're glad to have you today, Andy. Andy is a senior court management consultant whose work is at the forefront of court innovation. He's an expert in creating inclusive environments through language access and community-driven solutions. He has also pioneered data-driven strategies to improve appearance rates. Before joining the NCSC, Andy built an extensive foundation in advocacy with organizations such as the ACLU and Michigan Indian Legal Services. He holds a JD from the S.J. Quinney College of Law, and he's here today to share insights on making our dockets more equitable and effective. Next, we have Ms. Roxana Lilly. Roxana is a chief clerk at the Berryville District Court. Since her appointment in 2020, she has spearheaded initiatives to modernize court processes. A champion of procedural justice, Roxana collaborated with Arkansas Access to Justice to translate essential court forms into Spanish, Marshallese, Karen, and Chuukese, ensuring that language access is never a barrier to understanding court obligations. Roxana is currently completing an Arkansas Certified Court Management program and brings a wealth of private sector marketing expertise and public sector dedication to the bench. And finally, for those who I haven't had the pleasure to meet yet, my name is Edith Chavez de Oseguera. I serve as a contractor for Arkansas Access to Justice. I'm also the co-founder of United Law, a private firm in Northwest Arkansas. I earned my JD from the Bowen School of Law and graduated high honors from the University of Arkansas at Little Rock. My career in advocacy took root while serving as a Rule 15 law student at the Delta Clinic. I heard that perhaps Professor Penn was going to be joining us today, so I'll be delighted to see her. And volunteering for the Center for Arkansas Legal Services while I was living here in Central Arkansas. Driven by the examples of my grandfather and my sister, both attorneys, I am honored to continue their work as attorneys by supporting and strengthening our communities through access to justice. And well, I know that's enough about me, so let's move on to the real reason why we're here today. Let's talk about access to justice. So to understand our work at Access to Justice, it's helpful to look at the two pillars of our organization. First, we have the Arkansas Access to Justice Commission, which was established by the Arkansas Supreme Court in 2003. The commission serves as our strategic heart. Its mandate ensures that equal justice is served for every Arkansan, every Arkansan, by reaching the justice gap, proposing policy, legislative, and systemic changes, educating the public and the bar, as well as implementing programs that further its mission. Complementing this mission is the Access to Justice Foundation, which was established in 1984 as the Arkansas IOLTA Foundation. This 501c3 nonprofit is authorized by the Supreme Court to manage IOLTA program and funds. The foundation serves as our financial engine, reinvesting the IOLTA revenue and private donations back into the community through strategic grants. These funds support legal aid and fuel the very projects designed to advance justice across our state. A great example of those programs that we support is the Court Kiosk Program, which was implemented from a grant by the Administrative Office of the Courts and is maintained by Arkansas Access to Justice. The Courthouse Kiosk is an all-in-one platform set up with a computer and a printer that is available in the majority of circuit courts and some district courts. Another vital resource is the Arkansas Free Legal Answers Program. By using a simple web-based interface, we provide a lifeline for those in need of legal advice. It is accessible from any device in any geographic area. Its impact is truly statewide. We're proud to report that since the inception of the program, we have supported users in every one of the 75 counties in Arkansas, bridging the gap between rural communities and legal expertise. We're also currently working on deploying more online legal resources for pro se litigants who cannot afford an attorney, in partnership with Legal Aid, part of the initiatives that Nick is leading over there. And we are also proposing a model for a community justice worker to help increase accessibility in critical areas of law, such as eviction and consumer debt. Moreover, in an alignment with today's focus, we are supporting language access initiatives, which play a vital role in supporting our mission. By providing translated court forms to circuit and district courts, we complement the work of the Office of Court Interpreter Services, or OCIS. And so, as part of this mission is how we spark a collaboration with the Berryville District Court. Our discussion today stems from these two research projects, one completed by Access to Justice in partnership with Ms. Roxana Lilly and the Berryville District Court, kindly supported by Judge Dale Ramsey, and a study published by the National Center for State Court called Missing in Action. So today's session will draw data-driven roadmaps that will help us improve the justice system based on those findings. So to begin the conversations, I would like to first start with Andy and Hannah. So let's address the elephant in the courtroom. I know that there's some people that are what we call missing in action, but oftentimes we think about people missing court as an act of defiance or a volitional act, but it can be more than that. So can you explore with us why people are missing court, and let's ground ourselves and also define what is a missed appearance.
Yes, absolutely. And thank you so much. NCSC is thrilled to have the opportunity to be here. I think missed court appearances is an area where basically in every court that we speak with, it's a challenge, and people are I think really beginning to pay a lot of attention to it and explore it. So thrilled to be here and have the opportunity to talk more with you all. To start, we define, at least at the center and in our work, a missed appearance kind of both very broadly and very narrowly. Broadly in the sense that we think about missed appearances as any time a litigant misses a court event in their case, whether it's for in a civil case, criminal case, or any of those kind of in-between quasi-criminal case types, and regardless of the reason for their absence. So for whatever reason, they are unable to attend, and that hearing is not able to move forward the way it would have had the litigant been present. I think, as we just heard from Edith, there's a pretty strong misperception out there that the majority of folks who are missing court appearances are doing so out of defiance, out of an attempt to escape consequences, to try to prevent the judicial system from working as it's intended to. And data that both NCSC has gathered and also many others, including the Pew Charitable Trust and Ideas 42, has very consistently found that that's largely not the case. People are absent from court for a lot of other reasons, and generally because there are barriers preventing them, from appearing as they intended to. And the slide here just illustrates some of the most common ones that we see across. And again, multiple research studies keep indicating just the same reasons over and over. Big one is people are just not able to take time off work, particularly folks who are salaried, or excuse me, that are not salaried and are hourly, are not able to take the time off they need. Folks have a really difficult time finding childcare, and you can probably imagine, right, this is going to affect different populations differently. So younger folks between 20 and 40 much more likely to miss court as a result of inability to find childcare than other populations. Transportation is a huge one. Sometimes court dockets start before the earliest public transportation would even get them to a court, right? So people are unable to get there, or they can't pay for an Uber. There aren't Ubers. They don't have a working vehicle. Language barriers, I know we'll hear a lot more about that, but that's a huge piece, right? If folks actually are not able to read the information being given to them about when they need to arrive, what they need to do to prepare themselves, they're not going to make it into the courtroom. The biggest category that I put as unclear communications, and that in itself is a little bit unclear, apologies. But I think that's kind of a couple different pieces that come together. And one is court documents that are written in legalese, right? Lawyers like to talk in their legalese. That's fair, but it is really difficult to understand if you're someone who didn't have the opportunity to spend a lot of time in law school. So ensuring that there's plain language can be, kind of just a really easy step. And then also, I think those communications need to convey both the importance of attending court, what the consequences are when someone doesn't come, people who are juggling multiple stressors at the same time. If you're thinking about someone who's in the process of being evicted, perhaps, or is facing a charge, they're intimidated, they're nervous, they need information about why do I need to come to court? How do I make a plan? And then what's the consequence if I unfortunately don't come? And then finally, there's just a lot of fear and mistrust. And, understandably, I think in a lot of situations, people have questions that are unanswered and feel really nervous about what's going to happen when I come into this courtroom. Am I about to be arrested right away? Do I have an opportunity to get my thoughts together? Is the judge going to invite me to talk, or do I interrupt? Or how do I proceed? And people, I think, have a really tough time, and the result can sometimes be just turning away from the system instead. So just wanted to, those are some of the main categories, and we'll make sure also that our emails are included. And if anyone would like to see the studies, some of the specific data points, please feel free to reach out to us.
Thank you so much. And so I know that it impacts different areas of litigation in a different way. And so I would like you guys to help us understand, what the effect is across the different areas of law.
Yeah, absolutely. So this slide, I'm going to begin the slide with just some qualifications. These are sample rates of missed appearances in different case types from different courts of different sizes. They are not intended to be, this is our statement of how often folks are absent in consumer debt cases. We don't have that information for a couple of different reasons. One is this is not an area where courts always collect data. Sometimes people aren't tracking, particularly in civil cases, whether or not people are appearing, right? It might get just noted as a default judgment, and that's it. And we're trying to use that maybe as a stand-in or approximation. So sometimes it's a lack of data. I'll also add, of course, jurisdictions all operate differently. They have different processes. They also have different terminology that can make it really hard to compare. You've got some judges we know of who, if someone is not present in their eviction hearing, will pause the hearing and literally call the litigant on their cell phone and say, we're about to move forward with the default. Are you here? Do you want to participate? And so an absence in that court looks a lot different than an absence in a court where a judge is not taking that step per se. So anyway, sorry, I had to start with the caveats. What we have up here are just some samples that we see. So the first two, the non-traffic misdemeanor and the traffic misdemeanor percentages are how frequently, that's a statewide statistic, that's the same state, how frequently a case has at least one instance, potentially more than one, of a litigant, here would be a defendant not coming to court, right? So 10% and 20%. The middle statistic, that 56%, is from a very, very large urban jurisdiction, and it's measuring, again, the number of cases in which there's at least one instance of a defendant not appearing to respond to a civil offense, one of those, again, quasi-criminal charges. The next, at 70% evictions, is from also a really, really large urban jurisdiction. And this was actually before that court started implementing some reminder systems and solutions Andy and I are going to talk about. So before they tried to address appearance rates, they were seeing about a 70% default rate. And again, right, an example of data not being perfect, we're using default as a stand-in for a missed appearance. It's not always, a one-to-one. And then that final statistic, that greater than 70%, That we actually see fairly frequently in consumer debt cases. Multiple jurisdictions report over 70% of the consumer debt cases have a typically defendant who is not coming to court and is not participating in their court hearing.
Thank you, Hannah, for explaining that. And now that we know how it impacts different areas of law, how does it impact the individual? Can we explore that, Andy?
Yeah, we'd love to. And just want to echo our gratitude of being here with you all. And we're talking about stuff that we feel very strongly about. And so definitely reach out if you have any questions. So I think the impact on the individual, it can vary greatly depending on the case type that they're in. With criminal cases, we're talking about the potential of losing their liberty if they are, maybe they have a misdemeanor that could have been resolved with, a class and a fine, and now they have a warrant out because of an FTA, and the charges start accumulating, and that can really make it feel impossible for that individual to dig themselves out. In civil cases, there's also these extreme consequences. They could be losing their home. It could affect their livelihood with garnishments. So there's a lot of consequences that these individuals face. And I think part of what Hannah was touching on with the issue is a lot of folks don't understand these consequences before they get imposed. And then all of a sudden they have these court orders or a warrant, and there's almost a moment of, how did I get here? How did that initial charge turn into all of this? And so I think, you can see on the slide some of the things that we list out as impacts directly related to missed appearances. And I think that last one on the individual box, erosion of trust in the judicial process, that's a huge one. At the National Center for State Courts, we try to track kind of public perception of courts. And until this year, we saw public trust drop in courts by a lot over the last 4 and 5 years. So down to about 56% of people saying that they don't trust the legal processes. And so this has real ramifications as well. There have been studies ever since 2014 documenting that when people feel they have a fair shot at justice, when they feel like they're heard, they're going to comply more with court orders. They're going to appear more, and that's directly linked to their perception of procedural justice, not even if they win the case or not. And so I think these impacts, we can think about them as points in time, but they also build over time and are not just static at one moment in time.
Thank you, Andy. And I know that whenever we were conducting the research project with the Berryville District Court, we were able to find a lot of research done as to how it affects individuals, but really there's not that much going on the effects on the court. And so it was really refreshing when we saw the missing in action report. And so I would like for us to discuss a little bit more. What will be the impact? What's the impact on the courts whenever people don't show up?
Yeah, thank you. And I'm can't hold back my grin when you say that, because really that was the impetus for this work, is we had been looking so much at the effects on the individual and noticed that same gap, and really it's still, we started working on this a year and a half ago maybe. And so it's still very new for us, and we're not saying that what we're suggesting in terms of, we'll talk in a second about some of our models that we put forward, but it's still new to us, and we're still trying to validate the kind of hypotheses that we have around the effects on courts. But what I will say is, kind of in examining what we do know, we were able to categorize the impacts of courts into kind of 4 broad areas. And that was on the case flow and workload, so that, how courts are scheduling and having to reschedule, the kind of filing process after misappearance, and when there's duplicative work, when someone comes back to reopen a case, and so that kind of fits into the broader caseflow and workload. We also talk about downstream consequences, which those largely encompass the public trust and confidence in the courts, and directly related to that are compliance with court orders, paying fines and fees, kind of that whole realm of participating in not only the case but the outcomes of the case. We also recognize that missed appearances have an effect on staff, both on how courts decide to staff courtrooms, if they incorporate kind of this idea that, oh, we know 75% of individuals aren't going to show up for this consumer debt case. So even though the docket would usually require 2 clerks, we're just going to put 1. It can also really affect staff morale when, I think a lot of people who get into the judicial profession and the legal profession are doing so from a motivating factor wanting to help people or some kind of perception of what justice means to them. And in reality, when they're spending 4.5 hours just, writing warrants or issuing default judgments, that's not, at least from what we've kind of heard from court staff, that's not the reason they're getting into this field. And so it can be really demoralizing and can lead to, high turnover rates. And we know that with, training a new employee and all of that, it's a lot that goes into this. And so we really want to make sure that court staff are taken care of and thought of. And then this last kind of bucket is the area that we'll talk a little bit more about in detail. But we also tried to think about, is there a financial cost to courts for missed appearances? And the tricky thing with this is there's so much about a case that would happen regardless of whether someone misses their appearance or not, right? The judge is going to prepare for the case. The clerks are going to do the filings, the docketings. And then really when whoever misses that court date misses, we try to start tracking from there. What work is generated from that otherwise would not need to happen in the case? So really a lot of procedural considerations more than issues grounded in the legal issue. So we're certainly not trying to say that courts are wasteful or that they're using funding inappropriately. We're just trying to understand, how can court resources be utilized to ensure that people are receiving that, perception of justice and rewarding staff for, being able to do their job and feeling that kind of reward.
Yeah, this is something that actually in a conversation with Roxana, I was really surprised to see how much really behind the curtains it takes place whenever we have missed appearances. It's something that Roxana will explore here in a minute. But before doing that, I would like you to explain, I know that in the Missing in Action report, you guys came up with a formula of how to calculate the impact that it has on the court and costs. And so can you explain a little bit how to use this formula and how could we in Arkansas, adopt it or use it to measure the impact that it has?
Yeah, absolutely. And I think, so one, I'd say too, the idea behind the formula and the models is to help courts at least establish a baseline understanding of how their resources, which we usually think of as time and monetary and personnel resources, how are they being impacted when someone isn't coming? Missed appearances are kind of so baked into everyday court processes. They happen so much that sometimes it's really hard to get people just to stop and think about, okay, but how much time are you spending handling these issues? So to try to really just tease out that narrow piece, and it certainly, as Andy was mentioning, it's pretty tough to do sometimes to really parse out the difference between what would happen regardless and what's happening because someone has been absent. We put forth 2 separate models. They are meant to kind of just reflect the different responses that Andy outlined depending on case type when somebody's absent. So one of them is focused on, what we might say is like a stereotypical FTA in a criminal case. So it's one where you're assuming that likely a case event or a case hearing is not going to be able to move forward because the defendant themselves is not present in their case. There's going to be a hearing rescheduling. That's going to take some additional orders. There might be an FTA warrant issued. In some states, there might also be new charges filed against that defendant. There might also be a license suspension, right? And all of those are steps that the folks working so diligently behind the curtain are going to have to at least either fill out paperwork or process or send out to the parties. They're going to have to communicate with the prosecutor about what the next steps are. So that model tries to capture the kind of stereotypical, if you will, criminal response to a missed appearance. The second one tries to tease out how missed appearances affect courts that have those high volume civil case dockets. So thinking about consumer debt, eviction, sometimes small claims, depending on the jurisdiction. And there the work looks a lot different because the model sort of operates on the presumption that in most of those case types, if usually again, the defendant is absent, the hearing will still move forward. It might move forward differently than if they had been there and they maybe had the opportunity to present their case, but the hearing will still happen, and what will likely occur, right, is the default judgment will be entered against them. That's all kind of very hard to capture, and the result is often a really, really short hearing. Like a minute in some jurisdictions, 30 seconds, depending, right? Where the judge calls for someone, they don't answer, and that's it. That's been the hearing. The piece that appears in the high volume civil case area that we are working on trying to capture is also all the folks that come back later on and say, I didn't get notice. I didn't know I needed to be here when this default was entered. Or what do you mean there's a default? I didn't come to court. How is it possible that there's been a judgment? Or do I still have time to appeal? Can I file a motion to reopen? Do I get a chance to do anything at this point, right? And we've heard again in conversations with court staff that a lot of staff time gets spent resolving those questions and challenges. And of course, we know court staff are constantly kind of walking that really challenging line of navigating legal information versus legal advice, handling the fear and sometimes frustration and anger that court users might have when they come in and feel that something unjust has happened to them. And a lot of that can add up, again, if you've got a default judgment being issued when somebody wasn't present during the hearing. So the two models seek to separately try to quantify those. And really, they're pretty basic at their core. They're just trying to take a look at time spent on tasks and then the cost of labor of those involved with those tasks. The hard part about these models is that we're looking for, and they rely on data that a lot of court systems, I think for good reason and understandably, do not currently measure. And that's the hard part. So we're currently in the process of working with several jurisdictions to put these models into use. And then a lot of our work is just on the front side, figuring out how best to capture these variables that we need to do the quantification and how best to measure things like time, right? Time studies are not always fun. Court staff don't always like them, understandably. So trying to figure out how best to actually figure out the time going in. But those are the two models in there. The numbers that we use in the report itself, and again, I think that was linked in the materials and happy to send over afterwards, are kind of the best we could do at a national level, which is it's kind of silly to even say, right? Because it's so different at every jurisdiction. We have a 5-minute approximation of what happens, in terms of time when a defendant misses a criminal hearing. But that's an approximation that we've used as a stand-in in other NCSC work. And so I think, what these models really require is jurisdiction specific, really at the local level. This is something even I think you got to go beyond even state level. It should be kind of what's happening in your court to help you really understand. And the idea is just a baseline of where your resources are going when folks are missing their court dates to help you at least then think about, okay, were we to maybe increase appearances? How would our resources shift? We might not necessarily always be saving money, particularly in the high volume civil context, but we might be using our resources in a different way that is helping us pursue access to justice even more than we currently are. I will stop there. Please feel free, though, if there are questions about the models themselves. I really feel they look more intimidating than they are. They're basic, multiplication and addition, and it's really just about the data that goes into them.
You might have been a math major.
I was not.
But yeah, thank you so much for such valuable insight. Now let's pivot a little bit to the language access work and our partnership with the Berryville District Court. Roxana, I know that obviously in the country we have about 25 million individuals who are considered limited English proficient. And so in the state of Arkansas, the proficiency affects nearly 95,000 individuals. And in Carroll County, the data reveals that a concentrated need, because over half of the 12.9% of non-English speaking population requires language assistance. So these figures are definitely a call to action to ensure that the legal system is understandable for everyone so that their obligations can be met. And so I know within your court, you took action and the initiative really to translate court forms. And so I wanted to know what prompted you to do this.
So actually, it was I went to one of our spring district court clerk conferences here in Little Rock, and I believe it was Jason from Arkansas Office of the Courts Interpreter Services that mentioned that Arkansas Access to Justice will help get forms translated. And so I got back to the office that next week and I told Judge Ramsey, I was like, I got an idea. And so we started out with Spanish because that was the biggest number of people that we have. And then the Marshallese kept increasing. So then we started getting more Korean. And now we started out with 1 Chuukese, but now we're up to like 10. And we've even got an Albanian is fresh in our court. And so the languages are out there and people need to be able to understand, because I could see the frustration on their faces. They couldn't, even with an interpreter on the phone, explaining what we were trying to explain to them, they weren't getting it. And so it was the best thing I ever did, to be honest.
Thank you, Roxana, for that initiative. And so in our joint report that fines, fees, and failure to appear, the impact of translated court forms, it's a mouthful, I know. We observed that by removing language barriers through translated forms, the court actually saw an increase in revenue. And so we understand that external factors like population growth can skew that total revenue raise, but knowing that there wasn't really a significant increase in local population, and there is a connection between revenue collection and accessibility, it's hard to ignore the impact that your initiative had in your court. And so, how much has your court revenue grown since you started this initiative?
The first year was $31,984. That's only in the non-English speaking defendants. 2023, it went up to $51,471. 2024, $79,999. And then in 2025, last year was $93,000. That is a huge increase in revenue.
Thank you, Roxana. And now let's pivot into the failure to appear. Since we implemented this language access initiative, have you seen an impact on the failure to appear?
Yes, a big impact on it. As soon as we started giving out the translated forms, you could see that there became less failure to appears in those defendants. And then you could see it, they were coming back to court like they were supposed to, for the first time ever. And so it helped by 86.4% decrease in failure to appears in non-English speaking people. So there's no doubt that the translated forms have had a huge impact.
And I now thinking a little bit about our project together, I know that some of the forms that we translated are forms that they're even using at the local jail. Is that correct? And how are they using that?
So our Judge Ramsey, does the 8.1 hearings at the jail and sets bond hearings for everybody. On the misdemeanor cases, when they leave the jail, they get that paperwork in their language, if it's one of the 4 languages. And so they get that from the start. And then the first time they come to court, their rescheduled form is in their language. Then when they do come to court and they plead guilty or are found guilty, then we have them sign a time pay contract that's in their language. We may not be able to read it, because I believe that next slide will show you the difference in those. But our judge is very form happy. And so there's a form for everything. So this is our voluntary community service form. On the left-hand side is English. then Spanish, then Marshallese, and then if you notice Korean on this side. You can't read them unless you can read that language. So it's a good thing that all of our forms are,
Standardized.
yeah, they don't change because we can just fill out the line and we know what that's supposed to be. So, but you should see their faces. I mean, they're so excited when they get something in their own language. I had one guy almost cried. He had tears in his eyes, and he paid it in full that day, but he still wanted to take the paper. But yes, Judge.
I have a practical question, and I hope I'm not jumping ahead with this, but I mean, of course, this is just really a brilliant and obviously very impactful project. With the addition of this, are you all finding any issues accessing interpreters who can appear in court to be part of the proceedings? I mean, the forms are one thing, but then having someone have a person who's able to allow them to speak in their native language and for the judge to be able to hear from them in their words using an interpreter. I know that interpreters are in high demand, and so I'd like to hear about how that piece of this puzzle works.
So AOC Interpreter Services is absolutely amazing. Spanish is not so hard to get. Of course, since COVID, we have only had one interpreter show up in person because we've been doing most of those by phone or Zoom. And the hardest is Chuki's. There's only one, and she's very busy. So it would be nice if we had more of an interpreter pool, but we have no problems with Spanish, Marshallese, and even Korean has gotten a lot better. They usually can find somebody on the same day if I need them to, because the judge also uses those for the 8.1 hearings. So if they need an interpreter, the jail lets us know, and I get those scheduled. And sometimes he has to do those by Zoom at a later time during that day. But most of the time we can get one in the same day because Dawn, Beth, Jason, they're all incredible.
Also, the interpreters that I use, mostly Marshallese, can do simultaneous interpretation. And with simultaneous interpretation, it doesn't create an impediment for the process of the court system because they're able to communicate in real time. So.
Yeah, I don't know what we would do without them. You really can't because they don't understand. We actually had one that I was telling Edith about. We try to call people because they have review hearings every 3 minutes after they get set up on a time pay contract. That's to make sure that they're paying, turning in community service, or they get the next step in the program. And I could tell this person did not understand, even with an interpreter, and he's Marshallese. No, I believe he was Korean. And he was getting so frustrated. I issued a warrant because I actually had called to do the reminder call, read the note that my deputy clerk had put on his time pay contract. And so before I had to issue the warrant, I called AOC and I said, "Hey, Dawn, this is my issue. I've got somebody that's getting really frustrated because he cannot understand. And I would like for someone to help me call him and leave a message or talk to him in his language to make sure that he comes to court on Wednesday." So Pinky called and we did a conference call. We ended up leaving him 2 voicemails, but he still didn't come to court. So later, I believe it was the following Friday, he came in and I said, "I've already issued a warrant." And I ended up quashing the warrant because I got Pinky back on the phone. She talked to him for a good 45 minutes before he finally smiled and said, he got it. So sometimes even with an interpreter, it takes a little bit longer. But as long as they finally understand, it's worth it.
Thank you, Roxana. Particularly, thank you for going the extra mile all the time. I know within your court you do a lot. I know that you do reminders for court dates. You don't have a text system. That's, I know, probably coming up one of the strategies or suggestions, but it's definitely something that you do, that you call on a regular basis to ensure that people are showing up to court. And I think it has great impact on the community. But I want to talk a little bit about, before we wrap it up, about how much does it impact when a person doesn't show up to court? Like, what does the work look like whenever you're not, you have a lot of people that don't show up?
So, 3 weeks ago, I had to issue 57 failure to appears. That's for people that were scheduled throughout the month that had not come to court. And it took 4 hours to get those failure to appears ready for the judge to sign. And then once he came back into the office, of course, it takes him 20 minutes to sign them all. And then I get a big stack of warrants back. And then at that point, I have to put the official seal on, make copies, make lists for the Berryville Police Department or the Carroll County Sheriff's Office, whichever agency they go to, get those put in their boxes, and then I have to attach them all to their dockets. I have to go system their license, and then I have to file them. I spent 9 hours working on 57 warrants. It takes a lot.
Yeah, that's definitely a lot of work, and resources that could be utilized elsewhere. Now let's pivot into some of the takeaways, strategies, and recommendations. I know that Access to Justice provides grants for text notification systems for hearing dates. We had a grant that we awarded to a district court, and they're right now in the process of implementing that. But I also know that we have a lot of long-term policy proposals. One of them that we're working on right now is the informal pauperis rule proposal, and another one is the community justice worker model that will increase pro bono representation across the state. And so, as we conclude, I'd love to hear your final reflections on the work that we have done. And Roxana, given the success that we've seen with the language access in your courtroom, what are some of the primary takeaways? And what would you tell sister courts, particularly, I know that there's some judges here in the room, what would you recommend them do?
So the main takeaway for me is, like I said, the Marshallese that had tears in his eyes. I mean, that about got me because he was so excited to see something in his own language. And even though he paid it that day, he still wanted to take that piece of paper with him. And it amazes me when you have the interpreter on the phone and you put that piece of paper down in front of any of them, even Spanish, and their eyes light up like, aha, they care. And that's important to me. You know, we're not there to hurt them. We should be helping them. And if they can't understand what they're signing, that's not helping them. So I would recommend that all district courts, all circuit courts, reach out to Arkansas Access to Justice and get their forms translated. It helps. I mean, 86.4% decline in failure to appears is huge. And that was a very short amount of time that happened. So, yeah, I suggest everyone to do this. It will definitely help your court.
Thank you so much, Roxana. And Andy and Hannah, to leave our audience with a clear path forward, what are some of the key takeaways and some of the strategies you suggest us to implement here in Arkansas?
Yeah, I'll go ahead and start, and then Hannah can fill in. I think there's a few things. In a previous year, we created a tool called the Appearance Rate Report Card that breaks down kind of initiatives that courts can do to help get people to appear, and we think about them in three categories. We think about communication, so who's communicating to them at what points in time and how. I think part of what's lovely about being up here with Roxana is, language access is a huge piece of that. I think language access can also apply to English speakers, and are our forms in postgraduate reading levels, or are they closer to the 7th and 8th grade reading levels that are the national averages? So we think about that quite a bit, and using plain language, the legal information that people receive. We also think about access, so kind of those same barriers that Hannah touched on. We think of what are the ways that courts can help alleviate those. So, is there a family room or a lactation room in the court? That is a huge benefit that will get people there. Transportation, are they reimbursing for parking, for bus fares? All of that goes into kind of the just, including the physical layout of the court. Is it accessible for folks? And then kind of the third area that we think about and don't necessarily talk about quite as much, but is also just the actual policies and procedures of the court. Are we is it a rule that we presumptively issue an FTA warrant? Do we need to do that? Are there community input into the procedures in the court, and kind of the scheduling practices, and do litigants get to engage in that? So we kind of think about it in those three broad categories, but I would say low-hanging fruit and a really good place to start is just making sure that the legal information that we provide is sufficient for the person to understand so that they can meaningfully engage.
I can add just a couple, I think, additional ones. And one to this point, I think right now we're hearing a lot about reminder systems, automated or not automated, text message or phone calls. There's a lot of potential there. Absolutely. I think there's been a couple strong studies showing, around a 30% increase, at least in some jurisdictions when they've been adopted. I'll note we're also starting to see, of course, right, as we're rolling out a new technology, we're also seeing where its faults are. And e-reminders, in particular text message reminders, have been found, or people are starting to see they are not successful with certain groups of people, particularly those who are experiencing homelessness and who are unhoused, who have phone numbers that are changing frequently, are getting different phones, or maybe using a relative or family member's phone number, and then therefore the reminder isn't reaching them. We've also heard that they are less useful in rural areas. I think there's a lot more work there to understand what's going on. Is it because in those areas, is it transportation that's a bigger problem, and whether or not you get a reminder is not going to help you figure out how to get yourself, an hour away to court. I think anytime, right, we're adopting any kind of solution, we have to really be tailoring it and understanding first what are the community needs and what solution is actually going to address those needs, rather than kind of, trying broadly to assume that everyone's facing the same challenges just because, we know that they're not. And I think the last thing I'll just add to is that e-reminders can feel like a big lift for courts sometimes. It's bigger, particularly depending on your case management system, right? If it's expensive, if you have to, add on additional services. But there are also some really small lifts that we've seen courts work on. Some of them working around with other tech services, and then other times just changing calendaring practices. We've seen folks move away from cattle call dockets and do much more just bracketed short hearing time. So it's like 1 hour, and then you tell the litigant in advance, you will need to be here for this 1 hour time period, and then holding people, of course, to that schedule. Also enabling litigants to either participate in scheduling. That can be a bigger lift, but we've seen jurisdictions do that. So they are able to actually say, like, I have an immovable conflict on this day, I can't come. Or at least providing legal information about what are the steps to ask for a continuance. What do you need to tell the judicial officer about why you're asking for a continuance? So just I think there's really a spectrum of solutions, which is exciting. So if you're in a position where you're not able to do one of the bigger lifts, that doesn't mean that there aren't solutions. You can try to increase appearance rates. So lots of creativity here, which is, I think, really exciting. But I see a question. Yes.
I'm curious, a few years ago, I was doing some research about this, And I was really excited about a platform, Matterhorn, that lets litigants communicate with the court via software that they can access even on their mobile phone. Have very many jurisdictions adopted that or a similar platform? How does something like that fit into it?
I can't speak to that specific platform. I'm not familiar, but absolutely one of the solutions. And I think there's been slower uptake, understandably, right? That's a little bit of a bigger lift to get people in a position where they can
set up.
Yes, exactly. But no, that is absolutely an area where, right, the more, again, going back to that idea that Andy raised about, just procedural justice and people feeling like they have a real opportunity to be heard and participate in this system. A piece of that is being able to communicate, absolutely. So I think not one we've seen enough of. I hope we'll see some more. But yeah, absolutely.
Hi, good afternoon. Thank you so much for being here. My name is Tabitha, and I'm a foundation board member, and I practice in a rural area. And I was just curious if you guys have any strategies that you utilize for people who are very low literacy or completely illiterate, and if that's some of the issues that you see for the rural, why I think some strategies don't work in rural areas.
Yeah, absolutely. I mean, I think that goes back to Andy's initial, sorry, I'm speaking so loudly. To Andy's initial point about the legal information that's going out needs to meet the needs of your community. And that's, having again that understanding of what is our community's baseline literacy level. And if it is the fact that many people are not literate or at least are not reading at, say, a 6th to 8th grade level, what is the level, and then adopting resources. And it's hard, right? Plain language work is really hard, but it's absolutely doable. And maybe it's changing those plain language forms or summonses or citations, whatever documents are going out, and then also adding graphic information, and then also making a video that explains the same information so that people who maybe aren't able to read it themselves can still access it a lot of different ways. And that's true also, right, for folks who have different accessibility needs. The more ways you present the same information, the more people who are actually going to be able to understand it and then engage with it. If you want to add.
Yeah, I'll just add a specific example, and I'm excited to hear that you're interested in exploring community justice workers. And we've done community justice worker navigator work in many states now, most of them rural, so Kansas, Iowa, Wyoming, and enabling people in the community in which the folks live to feel like they can sit down and read the form to the person. And that's not legal advice. That is just information. You are reading what is out there. That's accessibility. And I think that goes both to the literacy, but also to the trust in who is telling them the information, And we've seen a lot of success integrating navigators into churches, into food banks, into these institutions that people go to and trust, because then it feels less like this, big outside person coming in and saying, here's what you need to do.
Judging them or yeah.
Exactly.
Thank you.
And I think this, go ahead, Shernay.
I'm Shernay, thank you. I am interested in the text message reminders, but I guess I'm concerned about the possibility of scams because we see so many of those text messages, and I wonder about like encryptions or how you can possibly ensure litigants that this is a legitimate text message from an actual court, because I can easily see someone saying, oh, this is a scam, or even if they believe it's legit, saying, well, I thought it was a scam, so I didn't come.
Yeah, it's funny that you mentioned that. I feel like I've gotten 3 texts in the last 2 months that are like, you have a warrant, but I know that I do not. It's clearly a scam. But someone who wasn't as familiar with the legal system or how to look that up would very much, panic. And I think that's a piece of this solution that's still a little more just like the Wild West in a way, people trying to figure out what efforts fall within the FCC regulations and opt-in versus opt-out. Are we giving them an option? Because if they opt in, then they should know they're going to come, right? And if it's an opt-out, they may feel more like it's a scam, but it'll reach more people. So there's a lot of kind of just like weighing these decisions. And I think a big piece of it too is the language of the reminder. We found the more just kind of plain language and conversational it is, the more trust there is in it. It feels like someone is reaching out to them, not just, oh, this is being sent to 500 people at the same time. But
I think the other just tiny piece I've seen too that courts try to do to address that is information on the court website that people can find independently that says you will receive a text message from us. The text message will have this, this, and this. If you have a question, this is a phone number that you can call so that people who are nervous still feel empowered and have the information they need to independently verify, right? And be able to pick up the phone, call the clerk's office or whomever it is that's going to pick up and say, like, did you actually send me this? And then they can say, yes, we did. You can expect future messages from us in this format when people are confused. But I mean, yeah, absolutely. The number of scams is overwhelming often.
And maybe say we will never ask you for money or for your personal information. So that do not answer.
Or click the link.
Or don't click the
Yeah.
link. Like you
Right.
just I think as long as you make it clear that you're not gathering information, that this is just a reminder.
Absolutely.
I think this is a perfect moment for a plug-in. How does one partner with the National Center for State Courts? We know you guys do great work. How do we get in touch with you guys?
Yeah, I mean, lots of avenues. You can reach out to us for our emails. Andy and I are doing and leading a lot of the work around appearance rates specifically, and we're always happy to set up a quick call. We'll probably send you a Calendly link, and you can schedule a time just to meet with us, and we can at least understand kind of what your needs are looking like. If there are specific areas you'll ask for help, and then we can move forward and try to plan from there. Sometimes the center has grant funds that we're able to use to work with different courts and different sites. That's actually how we're doing the work right now. We had enough to kind of work with a couple different courts, but hope to again have open dialogue. And if you have things outside of missed appearances, we're also happy. All things access to justice. I think everything I've heard Edith mention is work that we have also touched in other jurisdictions, and would be happy to hear also all the work that you're doing.
Are there questions online?
Yeah, are there any questions online, Megan? No?
I might just add to that as well. One thing, just because of the nature of our organization and being the National Center for State Courts, judicial buy-in, and if you have, I'm looking at Judge Moore. If there's a judge that's willing to do work, we will make it happen. And so sometimes, figuring out where the funding comes from for that can be tricky because we're largely not a funder, but we always are happy to work with, states and individual courts, whether it's helping them prepare their SJI applications, looking for other streams of funding. And so, yeah, I think if there's a willing court, a willing judge, then we're in.
We have one, it's a little long here. In unlawful detainer matters, the statute only requires a notice of hearing be sent via certified mail. Courts get pushback from landlords' attorneys when the court implements additional steps to ensure the tenant's appearance. The landlord attorneys will say that the court is deviating from only notice required by the statute. What are your recommendations for balancing both pro se tenant expectations and landlord expectations?
I can start. I think so. One piece that we see a lot is also folks forget, and sometimes it's helpful to get data on this too. The number of pro se landlords that are out there and who are also struggling with some of the procedures, information, how to appear, what you need, how to file properly. So when we're increasing access to legal information, that in itself, I think, is often not a one-sided act. That's every single person who comes to this courtroom, regardless of whether they are plaintiff, respondent, defendant, kind of whatever their position is, increasing that information is going to help everyone. And that also will help court staff be able to do their jobs better. That's hard sometimes. The other thing that we've seen work too is, engaging with the relevant stakeholders. So if you're looking at making changes in the eviction space, is engaging with landlords, landlord attorneys, and figuring out what are your concerns, what are your needs, if we suggest this change, how do you see that affecting you? How can we work together to move forward? And it's, that doesn't, you're not always going to get agreement on everything, of course, but there are definitely ways you can build trust with relevant stakeholders, regardless of case type. And I think figure out how to move forward regardless.
Yeah, and I'll just add, I think one thing so we have a program at the National Center called the Eviction Diversion Initiative, where we partnered with 24 courts across the country to try to address the unlawful detainer kind of crisis post-pandemic. And one thing that really helps, and it ties back to what we were saying about procedural justice, is when you sit down with the landlord attorneys and you kind of lay it out, it's, what you want from this is you either want the person out of the unit or you want to get paid for them to stay in the unit. And that's not gonna, either one is gonna be delayed if the tenant isn't aware, isn't participating. So really it's a benefit to everyone that they're aware, and we've seen that in those 24 sites we partnered with, that compliance, kind of the speed of resolution, it's all so much better when you have two parties engaging.
I would like to dovetail on that because I think some data collection around that would be really important. In Arkansas at least, if the tenant doesn't show, oftentimes the landlord can go ahead and proceed on the default basis. And, there may be a damages hearing, and then they're able to get everything that they want, at least as far as the legal resolution. But then in terms of the practical resolution after that, whether they're actually able to collect, whether some additional steps have to be taken to get the tenant out without damage to the property, I would be really curious, and this may be something to think about from the standpoint of some data collection and research around this, is the extent to which participation of both parties in these proceedings is able to result in ultimately better outcomes in terms of collections of overdue rent, a quicker move out time, while the tenant still gets an opportunity to have some time to be able to find another place to live and find some other arrangement, so that the ultimate resolution ends up being fair to all. I think that piggybacks onto what you say, but I feel like some data collection in that area would be really interesting to make the case that is something that is actually a benefit to everyone. I think we think and know it is intuitively, but I think that making that case to folks that are used to being able to bulldoze their way through and get what they want, at least in a court outcome, I think that would be really helpful.
Yeah, and as part of the Eviction Diversion Initiative, we require all of the courts to collect data, and so I will send you our reports from that. It's not exactly those data points, but I think we can draw a lot from that data, and I think when we're engaging with community resource organizations and, are we providing them information for if they have kids and moving school districts, what all do they need to get prepared for that? And is there rental assistance? Is there, if the landlord will agree to a 5-day move out instead of a 3-day move out, will they be able to secure, help for moving? And there's so much that goes into it. And when we involve the community, we know more.
All right. Well, thank you so much. This concludes our session today. Our sincere thanks to our wonderful panelists for sharing their wealth of expertise, to this wonderful audience for their time, and particularly to our board, whose support is what transforms our ideas into reality. So have a wonderful rest of your day. Please enjoy your lunch, and thank you so much for being here today.